The Law Collaborative presents Ron and Robert on Divorce. Here are attorneys Ronald Supanchik and Robert Borski with California Family Law. And welcome, Robert Borski here for Ron and Robert on Divorce with my partner,
Ron Supanchik.
And our very special guest, the Honorable Judge Thomas Trent Lewis.
Yes, and we left off our last segment talking about the retiring Supreme Court Chief Justice Ronald George, who left a wonderful legacy of innovations and improvements to the California system, but one of them that directly applies to family law happens to be the Elkins Report, a 2-year task force study that came out last October, suggesting improvements and refinements that could be made to the California family law. And I believe, Judge Lewis, you had some hand in that, and a part of that, I'd like to hear your thoughts, ideas, and reflections on Elkins.
Well, sure. Actually, my involvement in Elkins has been more advisory to people who are on the Elkins Commission. Just a quick summary, and I think you gave a good one, but Elkins is a case, Elkins versus Superior Court. As you said, the Chief Justice appointed an Elkins task force to analyze how family law works in California because of some concerns about access and fairness. And the Elkins task force, their technical responsibility is to report to the Judicial Council. And the Judicial Council itself has within it a commission called the Family Law and Juvenile Advisory Commission. So the Elkins Task Force will report to the Advisory Commission. The Advisory Commission will report to the full Judicial Council. Of course, it's government, so it's got to have a couple of layers in there, and it certainly does. And I sit on the Family Law Advisory, Juvenile and Advisory Commission. So the Elkins Task Force rendered a report, like you said. The task force traveled up and down the state, got a lot of information, heard from all manner of voices, from judges to lawyers to self-represented to lots of different stakeholders within the family law system. And they wrote a series of recommendations, and those recommendations include a variety of different things, including questions concerning how the cases will be managed, how they'll be presented, how the parties have access to the system, and tracking almost parallel to that is an assembly bill from Assemblyman Mike Fuhrer, who's the chair of the Assembly Judiciary, and that's AB 939. And AB 939 is working its way. It's a 2-year bill that went in a year ago, and it's starting to develop a fairly strong head of steam towards getting passed. And AB 939, among other things, talks about the management of resources of family law. And that's probably the most compelling aspect of what we've learned through Elkins. In many ways, what Elkins taught us is that which we already knew. Unfortunately, in a world of diminishing resources, family court does not get adequate resources. It doesn't have enough judges assigned to it. It represents a large portion of the filings on an annualized basis. If you back out traffic and just look at family law overall, it represents a large percentage of the civil filings, but it gets a much smaller percentage of the judicial resources. And the Elkins Task Force is asking for more of those judicial resources. One of the most important tools that the family law judge needs and doesn't have today, except by stipulation, is the ability to order case management. Case management in family law is a long overdue tool available to judges to assure fairness, not to assure a rush to judgment or strengthening the hand of the moneyed spouse, but to assure fairness and access and a prompt resolution, taking into account the other sensitivity that comes to family law, which is, when is the family ready to get a divorce? Not are they getting a divorce, but when are they ready to have their divorce finalized? Some families need more time to actually process the idea of the breakup. Some families reconcile. And so if it's an automobile accident case, well, they're not going to reconcile. Somebody's going to pay money or not pay money. If it's a commercial piece of litigation, somebody's going to owe somebody money, or there's going to be some reformation of a contract. But in a family law case, some families decide, you know what, we don't want to get a divorce. So that's a sensitive area, and it's probably going to be what will capture the imagination of the family law bar and bench over the next few years is actual implementation of case management in family law.
Where do you see ADR, alternative dispute resolution methods such as early case evaluation, mediation, collaboration? Where do you see that playing out? It's mentioned and discussed in Elkins, and I'm curious as to what your thoughts are on those options.
Well, I've always been a fan of early neutral evaluation of cases from the judge's side. I am a firm believer in attempts at mediation of cases in any setting, because I think that it gives the parties that which a judge will never give them because of the way the system works. Parties can settle their case with a far greater degree of flexibility, imagination, and understanding than a judge will ever bring to the table, and no matter how much evidence they receive, no matter how much they work hard to make a good decision. So parties who self-determine and mediate their case, I think, always have a better outcome overall. Some cases that's not true, but some cases just don't mediate. Relocation cases don't mediate. What Mom wants to move to New York, Dad wants the kids to stay in Los Angeles. What are they going to move to Kansas as a midpoint? Obviously, no. So relocation cases are the kinds of cases that frequently it needs a judge to make a decision if there's really a good faith dispute, and that those kinds of cases don't settle. But most family law cases are really more like business litigation. If you back out the kids and you back out the emotion, it's about making a good business decision about finances. And litigation is, frankly, not always the best place to resolve those kinds of controversies, because ultimately the parties want to have more to divide between them, and the cost of litigation being as high as they are, things like collaborative divorce, things like alternative dispute resolution, mediation, early neutral evaluation of a case, how much is it going to cost to actually move your case forward? I think those are very, very useful tools. They're certainly strongly encouraged by the statutes and by judges as well as a way for parties to have quicker resolution, and if they can afford to hire a rent-a-judge to do their case, then certainly there's lots of advantages there that the public system doesn't offer.
As difficult as it certainly is, I actually had the case where Mom wanted to move to New York. Dad wanted to keep the 7-year-old son here in Beverly Hills. And it was a collaborative case, which is really conjoint mediation, because all the techniques of mediation are fully employed. We brought in a parent coordinator, and she spent about 4 months with Mom and Dad. Dad bought her a house in Beverly Hills within a bicycle's drive of the same school, and Mom agreed, based on giving her $20,000 a month of financial resources. She agreed to be bi-coastal, live in New York, and stay 1 week, a week on, a week off with the 7-year-old, so the boy could stay in the school, have the same doctor, tutor, and musician lessons. And we actually did mediate a case like that, so I know they're difficult and not likely, but where people are given the opportunity and the resources, they can be very creative and do things that judges don't often have the time or inclination to do.
That's a great example of using ADR.
And I would also just add to that, the example that Ron used is great. And there may be some of our listeners who are saying, yeah, but those people could afford 2 houses in Beverly Hills and they're bi-coastal. And it works also with a family who has much less. And we'll be back right after we hear from this gentleman.